sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant wish to reserve any time for rebuttal, let me know when you get started on keeping track of the clock. You can also reference it on the wall over there. Please don't use the names of any victims or minors. I don't think it's relevant in this case. We like to always make that admonishment as these arguments are being recorded and will be placed on the court's YouTube channel. Please introduce yourself and stay behind the podium. As I indicated, these are being recorded. Counsel, would you like to reserve any time for rebuttal?
Yes, Your Honor, 5 minutes, please.
Certainly. Thank you. Proceed.
Thank you. If it pleases the court, my name is Troy Doucette. I represent the appellants in this matter. I have represented folks facing foreclosure for quite some time. It's a number of years. And one of the things that I hear most frequently from people who call me is that despite some hardship, despite a couple of payments that they miss, they want to get back on track. They want to find a way to pay their mortgage. They want to find a way to move forward. They're not looking for a handout. They're not looking for a free ride or even a free house. It's all about how do they move forward in their lives after something usually catastrophic happens to them. In this case, COVID is what happened to my clients. It happened, to all of us, where there's a complete shutdown in the economy. This is a hotel. These are underlying hotels that we're talking about. A hotel we're talking about, and my client had payment issues. Fortunately, the federal government had plans, had payment options that allowed the lender to get paid, to have payments that it received on behalf of borrowers such as mine, to keep them current. That payment happened in this case for a period of time. However, at some point the government changed the guidelines where they reduced the amount of money. There was a lot of confusion with the two sides as far as what that meant and what the payments needed to be. During that time period, my client was ready, able, and willing to make all necessary payments to match whatever the government was no longer doing, and in fact did. There comes a point where...
But they didn't until after they didn't, and when there was a partial payment that was cut down, there's still payment that was due that was not paid, right?
Yes, it was a confusion on both sides as far as what that payment was supposed to be. There was no letter to my client saying, hey, you've got a lower amount now that you've got that the government's paying us that you need to make up. The issue was this: there was no notice, there's no information surrounding it. As soon as my client figured that out, as soon as the two parties were able to communicate and figure that out, my client made all of it up. In fact, not only did it make it up, but then they filed foreclosure, and my client continued to pay the mortgage for about 6 months after that. So this is a situation where my client was completely ready, able, and willing to make payments. The underlying issue that we have from a legal standpoint, while we're in the Court of Appeals, is then what's the obligation of the bank, both pre-alleged default and post. Pre-alleged default, we're dealing with the SBA guidelines. This is an SBA loan. The lender receives money from the federal government to service this loan. The lender received 6 figures from the government, federal government, during COVID for this loan, and this loan is underlying is SBA guarantee. And there's a clause within the loan itself that says this loan is going to be governed by the SBA guidelines. All of that taken as a backdrop, then I see the top number, excuse me, I'm trying to figure that out. That as a backdrop, the lender has some obligation to go to the SBA and say, hey, we've got this non-performing loan. We need some kind of communication and plan surrounding it in order to move forward, in order to figure out what to do next. And the reason why the SBA does that is so we can all avoid a foreclosure. SBA has a significant interest in avoiding a foreclosure, not just because of the impact on our community, obviously my client, his family, their family, but also because the SBA is going to take a bath if a foreclosure goes through, and that's what's happening here.
Would your client have ever gotten notice if they would have complied with the SBA procedure? Would your client be involved in that?
Well, what the SBA would have required is a question mark. So for my client's perspective, the answer would be yes, because the SBA would have said, where are we at? what alternatives are available, and then they would have come to my client and said, here's our obligations, here's the universe that you're gonna be working within. And then our client would have, again, the issue was not our client not being ready, able, and willing to make the payment. That's not because he did. Every penny they claimed was due, he paid back. He paid them. He even paid them after the litigation began.
But that was after notice of default, right? There was a period of time where there wasn't payment made in full.
There's a March due date, March, April, and then in my months, April, May, somewhere in that range. There's communication back and forth between him and the bank. So the underlying court decision doesn't go through the factual back and forth that was alleged, that the evidence was presented for in the decision, but there's communication between the two on it. So the idea that the bank can just claim a default doesn't happen in a vacuum. It has obligations before that, and those obligations are under the SBA. It's very similar to what the court is, what we've all done with FHA guidelines, just conditions preceding foreclosures, right? It doesn't say in a mortgage, yes, they shall do this or that or the other thing. The FHA guidelines govern the transaction. The borrowers are third-party beneficiaries of those guidelines. Similarly here, the SBA guidelines lay out something that is required of the bank for the benefit of the consumer. That's why it's in that reference in the note. So the default in itself, even if that we can set that up and assume for a second, arguendo, that default occurred, there are still things the bank has to do beforehand before it goes to that step, and it did not do that in this case. Had it done that, had any communication gone back and forth, they didn't even provide notice of this litigation or provide notice of the dollar figure that needed to be cured. They just said you're in default. My client would have paid that because he ultimately did. Secondarily, even if we assume that default occurred, there are still obligations on the bank, on any non-breaching party in a contract action, to take after the date of default. And that's failure, and that's mitigation of damages. It has to take certain conduct to mitigate its damages. In this case, one of the things I want to focus on most is that my client had somebody come up, offered $1.8 million for this property, which would have paid the loan. And they said no, they ignored it is what they did. And then the offer went away. We have alleged that failing to take that, even assuming that they fully accelerated and everything was due, when my client comes to the table and says, we've got a ready, able, and willing buyer, they've got an obligation to mitigate their damages, which they failed to do here.
There was a contract provision that said even making payments, even going back to even getting current with your payments doesn't you're still in default. So mitigation of damages, here, there's a contract provision though that says something different.
There's two
Right.
veins to that, right?
Yeah.
So the vein you're talking about is, assuming we go with that language, is that you can't come up and make it good.
Right.
The second vein of that is, you can still pay it all off. So that's what my client was attempting to do, was pay off the entire amount. And that is what they failed to mitigate. We still contend that they have
So you're saying the acceleration clause kicked in and your client is willing to pay the total amount?
Exactly correct, yeah. And there's evidence before the trial court, and it's on, I think, the last page or second last page of our briefs as well. Taking a step back for a moment, even if we don't have any sympathy for the borrowers who are obviously lost a livelihood, and the bank again has obligations under federal guidelines. They're getting paid by our tax dollars to service this loan. They're getting paid by our tax dollars if and when after the property goes to sale and there's a deficiency judgment. Who's going to be paying that? It's not my client. Their property is collapsed. It's going to be us, the taxpayers, through the SBA obligation. So the bank, the way we perceive it is, The bank was getting, COVID happens, the bank gets payments directly from the federal government during COVID. Things changed, it's messy, there's not a lot of information, clients willing to pay, borrowers are willing to pay back. They say, you know what, your money has run out under the federal government, we don't want you to become current, even though it's peanuts. We want that governmental money, so we're gonna go ahead and file foreclosure. The foreclosure's gonna run through, there's gonna be deficiency judgment, and bank, Berkshire, is gonna be made whole through the SBA. People talking about like the bank's not wanting to have foreclosure because they're gonna lose money. In this case, that's not true because they are getting made whole by our federal government.
So your arguments sound like public policy, because how do you answer those cases quoted by the appellee in his brief that compliance with an SBA agreement, including obtaining SBA approval of the lender's litigation plan, are not conditions precedent to a foreclosure action, and therefore cannot be raised as a valid defense? And then it goes on to cite cases where participation agreement was clearly an agreement between the bank and the Small Business Administration for their mutual benefit and created no legal rights or duties to the defendants. So there's multiple cases like this. Is this a public policy argument you're making then, that the SBA's?
Well, there's a differentiation between those cases. So if you look into them a little bit more, they are saying that there's no private cause of action, and I tend to agree with that. So I'm okay that there's no private cause of action. My client can't file a new lawsuit for that. However, as a conditions precedent, as a defense, the case we cite out of the 10th District says it can be argued as a defense. And I think that's the main difference between their site. It looks impressive because there's a bunch of them, but really they're dealing with affirmative causes of action versus acting as a defense. The underlying public policy of the code, of the reason why we have the regulation, is to prevent foreclosures, to enable borrowers that have SBA loans to prevent default, because it obliterates their livelihood, it obliterates the family, not to mention the community that they're in. There's a strong public policy behind it.
And counsel, I need to let you know, you don't have to sit down, but I wanted to let you know, you've reached into that 5 minutes, you have about 3.5 minutes left, you can continue or reserve.
I'll go ahead and reserve, thank you.
Okay.
May it please the court, my name is John Worthland. I represent Berkshire Bank, the appellee in this case. There is no confusion whatsoever, Your Honors, in the application of these payments. My client, and the representative of my client, Mr. Mateak, was very clear in his emails that are attached to the affidavits before the court as to the payments that needed to be made, and the fact that the CARES payments were reduced in 2021 to $9,000 and that the borrower had to pay the balance owed. My client was very clear in telling the borrower that, and in fact the borrower knew it and tried to pay the balance, or did pay the balance of payments on June 21st, after the loan had been accelerated. I'll get into that in a minute, but one thing I do want to emphasize to the court is that this is a commercial loan. It's not a residential loan, and therefore there is no unequal bargaining positions between a borrower and a lender. They're on separate, or they're on completely equal footing, and there's no presumption that my client, or there's no presumption that the document should be read against my client because this is a commercial loan. What happened here was that the borrowers did not pay the commercial loan, and my client exercised its rights under the loan documents as agreed to by the borrower. The loan was due for the April 1st, 2021 payment. The notice of default and acceleration was sent out May 27th, and suit was filed on July 2nd, 2021. When the notice of the default and acceleration went out on May 27th, the entire amount of the balance, the entire amount of the loan was accelerated and thereby due. And counsel for appellant is trying to say that the borrowers were ready, willing, and able to make these payments in addition to the CARES payments, but the record belies that response, because The CARE payments were made by the U.S. government on April 1st and May 1st of 2021, but the borrowers didn't tender the balance of the payments until June 17th, 2021, which was 1.5 and 2.5 months after the April and May CARES payments were made. So they weren't ready, willing, and able. They delayed 6 months to make the 6 weeks to make the payments.
When was the note accelerated?
The note was accelerated on May the 27th. So these payments were made after the acceleration of the note at a time when the entire loan balance was due.
And remind me, what did the bank do when they made that offer to pay everything, or they actually accepted the money, right?
The money that was tendered on June 17th, yes, the bank did take that money, but the representative from the bank told the borrower that we will accept this money, but we are still considering that the loan is completely accelerated and all amounts under the loan are due and payable, which the bank is entitled to do under the terms of the loan documents.
So I know your position is that unlike the appellant mentioned, the FHA loans, which we are most familiar with in this court because, you know, with the consumers and so forth. And there's so many stopgap measures that are in place involving homeowners. So it's your position that none of the SBA regulations impact this whatsoever, that there are no requirements that you had to meet before you could just go ahead and foreclose on the small business?
That's correct, Your Honor. That's vis-a-vis the borrower. And the case law in my brief, not to belabor that point, but I'd just like to cite to some of these cases very quickly. The United States versus Martin case says the SBA agreement was between the bank and the SBA and creates no right in the defendant. There's no distinction in these cases between using a violation of an SBA reg or failure to comply with an SBA reg as an affirmative defense versus a cause of action. These cases say there's no right, so that means neither as an affirmative defense or a cause of action.
But then, why, is it just for informational purposes that the counter-argument is that Berkshire considered this lawsuit routine and non-contested? In other words, what difference would it make if there were no ability for the borrower to use the SBA guidelines?
That's vis-a-vis the SBA and the lender. That's based upon that agreement solely between the SBA and the lender. If the lender doesn't follow the SBA regs, that's as between the SBA and the lender as to the enforcement of the guarantee.
And that's the sole reason why that argument was proffered? Because why would it matter how it was characterized if the borrower, who's the only person who's in this lawsuit, borrowers, I'm sorry, there are guarantors, why would it matter how Berkshire characterized?
Well, the characterization of routine versus non-routine only applies to the relationship between Berkshire and the SBA. And whether or not Berkshire followed the SBA regulations and guidelines in order to have an enforceable guarantee to be paid by the SBA. That's it. And the cases point out that that's an agreement between the lender and the SBA, and a borrower has no right and no standing to enforce those regulations.
Okay, and am I missing that the SBA is one of the parties to this lawsuit?
It is not. It is not. And another point I'd like to bring up to the court, based on the documentation, is that the note says that the SBA regs apply to this transaction only if the SBA is the holder of the note and the mortgage. And the SBA is not the holder of the note and mortgage in this case. Berkshire Bank is. And therefore the regulations don't apply at all by virtue of the contract.
So it was just a misnomer to put that in there about what Judge Hensel's talking about routine and non-contested.
Well,
Because you didn't have any obligation whatsoever. The SBA didn't have any control over this loan whatsoever.
Based on the documents,
Okay,
it's,
so-
the terms of, the SBA regulations do not apply to the loan. It doesn't mean that there's not a contract between the SBA and the borrower, or the
Right,
lender.
but you said that these only relate to the relationship between the SBA and the bank, and the bank is a holder of the note, so that the SBA regulations don't apply whatsoever. I thought that's what you said.
Right, that's right, as to the workout and the filing of the foreclosure action.
Right, so why does it matter whether it's routine or non-contested?
Well, my point is, it doesn't vis-à-vis the borrower.
So, but you just said you're not under obligation, maybe I'm misunderstanding you. I thought you
Well,
said
I mean,
you're
it's-
under obligation to the SBA either.
Well, if the SBA regs do apply, and my client's required to characterize it either as routine or non-routine, that's an obligation between my client and the SBA. The borrower has no standing. But I also argue that the loan documents also say that the SBA regs don't apply, or only apply to the SBA if the SBA is the holder of the note in the mortgage, and the SBA is not the holder of the note in the mortgage.
Now, I know from prior experience, and I know this is residential and it's consumer oriented, the FHA loans. The language is actually in the loan documents regarding notices that they are required in FHA loans. Not in this record, but my question is this: we haven't yet had the opportunity to comb through the loan and security documents. Are there references to this being an SBA loan governed by those laws in those documents themselves?
Well, there's a reference to it being an SBA loan, yes. But there's also the reference that the SBA or federal law applies only if the SBA is the holder of the note in the mortgage.
And that's in the actual contract?
It's in the note, I believe it's in the mortgage statement. How much time do I have left?
5 minutes and 15 seconds.
Oh, okay. Just to again point out, the Ameritrust case that the appellant is relying upon is an outlier case, and I would respectfully request and ask that this court disregard that case because it is not good law. It has not been cited by any other case for 30 years. The case has to do with allowing the failure to follow a reg, an SBA reg, to be an affirmative defense to a foreclosure. No other case, another court has followed that law. It's a 10th Circuit case, and this court is not obligated to follow that decision. Moreover, as we just discussed, the Ameritrust case is irrelevant because the SBA regs truly don't apply to this loan as we discussed, because the loan documents state that they only apply if the SBA is the holder of the notes, or the loan documents. Appellant's counsel did discuss the failure to mitigate damages and the failure to give notice of the default, which the record certainly belies that also. As the trial court pointed out, my client representative, Tom Mateak, was in constant contact with the borrowers, attempted to help them in all respects, and actually set up these care payments for the borrower and help them get these care payments. Further, based on a contract basis, both parties agreed to the remedies in the loan documents, and Berkshire Bank was simply availing itself of its remedies in the loan documents. Counsel also stated that his client didn't get notice of the default, which is, frankly, it's just not true. We have an affidavit in which we indicated that the service of the notice of default was sent by mail and regular mail to the borrower, and in fact, the certified mail service came back signed by the borrower to the same address that had been used for previous default letters.
Was the default letters also the acceleration notice?
Yes, Your Honor, so it was notice of default and acceleration. Moreover, both the guarantors and the borrower waived notice of default in the loan documents. As to the guarantors, Section 6, subsection B2 of the guarantees clearly says that the guarantors waived notice of default. Also, the note in mortgage is also clear that as to the borrower, the notice of default and default and acceleration could be executed immediately without notice to the borrower. This is a case, an unfortunate case for the borrower, obviously, but the borrower is a savvy commercial borrower. They've been there before, they know what they're doing, they're familiar with commercial loans, they knew what they were getting into when they signed loan documents, and they knew what the implications were if they didn't make their payments. As to the conditions preceding, they just do not apply per the case law that I've cited to the court. The trial court's decision was correct in all aspects, well-written decision. I submit to the court that it's correct, and I ask the court to affirm the judgment in favor of my client.
Thank you, counsel. You'll have about 3.5 minutes, it's the top circle.
Thank you. You know, I have to step back for just a minute. I just, you know, there wasn't any testimony, even an argument that there was a communication with SBA about routine or non-routine. There's no, by the lender, there's no communication, there's no evidence that they followed SBA guidelines whatsoever. And you know, the acceleration letter, May 27th, and then 3 weeks later, my client makes a full payment. I guess I'm taking a step back a little bit lost as far as why we're here, why I'm standing here. It would seem to me that any foreclosure, any lender decision to proceed with foreclosure should be in a different set of facts, a different set of circumstances, not having a borrower who pays you, makes you whole within 3 weeks, continues to pay it for months even after litigation begins, when the lender doesn't take any steps whatsoever to follow its own obligations under the SBA to properly account for and service this loan. I mean, it's almost like the argument is, we'll send you a piece of paper, you can't communicate with us, you can't challenge it, you can't say anything to us, you just have to, you can't even pay it back. Too bad for you, we're off to foreclosure. I don't understand why, of the situations that lenders foreclose, this would be a situation that would warrant it.
You know, in non-commercial mortgages, when we deal with foreclosure, it is a equitable proceeding. What do you say in regard to that with the Small Business Administration?
Well,
In other words, we have a two-step process. We see if there's been a default, and then is it equitable to foreclose?
yeah, I think that we're equitable, yes. Yeah, a foreclosure is an equitable, an action under mortgage foreclosure action is equitable. That's correct. And there definitely was not analysis done on the equity side of things.
On the equity of whether foreclosure was warranted.
Correct, yes, sir. No other questions? Thank you very much.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which we mail to all parties to this appeal as on the day it is issued by the clerk of courts, as well as posted on the hospital